Welcome to Rock Center Shorts. I'm Kristen Savell, Co-Executive Director at the Rock Center for Corporate Governance at Stanford. I have two guest speakers with me today. Dave Larcker is the James Irvin Miller Professor of Accounting Emeritus at Stanford's Graduate School of Business. Dave is also Director of the Corporate Governance Research Initiative and Senior Faculty at the Rock Center for Corporate Governance. Dave's research focuses on executive compensation, corporate governance, and managerial accounting. Before coming to Stanford, Dave taught at Wharton and the Kellogg Graduate School of Management at Northwestern University. Joe Grundfest is the W.A. Franke Professor of Law and Business Emeritus at Stanford Law School and Senior Faculty at the Rock Center for Corporate Governance. Joe's research focuses on capital markets, corporate governance, and securities litigation. Before joining the Stanford Law School faculty, Joe was a commissioner of the Securities and Exchange Commission and served on the staff of the President's Council of Economic Advisors as counsel and senior economist for legal and regulatory matters. Welcome, Dave and Joe.
Thanks. Good to be here.
Great, Kristen.
Good to have you.
Dave.
Last week on January 30th, a Delaware judge struck down the $56 billion pay package that Tesla granted to Elon Musk in 2018, which was the largest compensation package in public company history. Today, we're going to talk about that decision and its implications for Musk, Tesla, and for companies more generally. Dave, as a refresher, can you highlight the terms of Musk's 2018 pay package?
Yeah, sure. I can do it, in a very simplified way. So in 18, the board at Tesla agreed to what we call a mega grant sort of program. And, these things have existed for, a while, but they're pretty rare. And this one was quite large. And so the terms of the contract were there were 12 tranches of performance criteria that were related to satisfying targets on market cap, revenue, and EBITDA. And if Musk hit these targets, say in one of the tranches, which required both market cap and operating performance to exceed the targets, he got 1% of the number of shares outstanding at Tesla at the date of the grant in terms of options. And so these things would vest at that point, and then he had to hold them, I believe, 5 years. And so there's always some debate about what the value of this is. There's the expected value of this contract, which take the risk that you couldn't hit these pretty aggressive targets. And then there's the payout, and so the number that floats around is 50 billion or something. But at the time of the grant, the expected value is much lower than that. And so there's some debate about that. But all the numbers are quite large, but the targets are also very, very, very stiff.
Let me expand on a couple of things that Dave just hit, and then let me drill down on what I think is a very important question that the press does not pick up on, but I think legally is potentially critical. First, how unusual is this? According to the court's opinion, this pay package is 250 times larger than the median peer compensation, and 33 times larger than the highest analogous comparable. And the prior record holder was the previous deal that Musk cut with Tesla. So, in terms of the constellation of compensation, this one is way the heck out there on the extreme of the distribution, no matter how you look at it. But Dave hit on another point that I'd like to drill down on. The $56 billion valuation kicks in because all of the milestones and all of the metrics were met. However, as of the date of grant, the fair value of this package was reported to be $2.6 billion.
Right.
And nothing in this opinion says that that number is wrong. Now, here's a question for you. What is this pay package really worth? Dave, is it 55.6 billion or 8 billion, or is it 2.6 billion? What's
no, I mean, it's the, the expected value and the realized value. They're obviously different numbers. And, but I think the other thing Joe was leading up to is the targets that were set. I haven't done a rigorous analysis of this, but here's a company for everything to kick in. You had to go from 50 billion in market cap to I think 650 billion. I mean, I'm not sure that's ever been done.
Precisely.
And so I think the debate, this is true in exec comp anyway, it's like, here's this gigantic number, and it was paid out, or here's some expected value. But I mean, it could also end up at zero if you don't hit these targets. So I think that part is a little bit missing in the opinion.
Exactly right. And for perfectly understandable reasons, the court in this case, perfectly understandable, although not necessarily the most accurate reasons, the court focuses and dilates on that $55.8 billion number, and the press is all over that number. Heck, if I was a reporter, I would do that too. But maybe the more accurate number from a different perspective is 2.6 billion. And as Dave said, the amount of value that would have to be created in order to max out on this contract is something that may never before have happened. And if you have unprecedented targets, isn't there an argument for unprecedented pay, assuming you go about that process correctly? And
Oh,
it's
that's
the
right.
process here
Yeah.
that's the real issue.
Well, before we get into that, let me ask a practical question. Has Musk exercised any of the options that were awarded under this pay package?
I don't know the answer to this, but my impression was the answer was no. But I believe that, they're vested now. And I guess one thing we should talk about is, he's probably borrowed against these options as collateral. So if the contract is rescinded, it raises some pretty interesting questions about his personal financial position and the cascading effect of raising money like that. So I think that I think you have to hold these options for 5 years, or hold the stock that you would get from the options for 5 years. So there's another, that's another risk. These things, they could vest, but when you actually go to cash, what's the real number? So I think Joe's right. We toss these numbers around like they're all the same number, but what's expected, what you took home, what's realized, that type of thing. They're very, very different numbers. And I'm speaking more from an economic point of view. I'm not sure what the legal theories are, what's the right number from the court's decision, or if you're going to rescind this thing, what's the number that, is being rescinded. These are very complex sort of things in my mind.
Yeah,
Right.
Dave is right. I mean, I don't recall. I think some of the options may have been exercised, but he still holds that stock. My recollection could be off on that. But the court is clearly of the view that rescission here is easy. All right. If you still have the stock, you just give the stock back. And if the options have since vested but not yet been exercised, you just cancel the options and we're done. Dave says, wait a minute, not so fast. In addition to the possibility that these options of the stock has been pledged, all right, for a loan, what about the tax effects, Dave? All right.
No, that's right. I mean,
I
no, there are a lot of nuances, I mean, of this thing. And it seems like, well, you have to give that back, but what it is, not so obvious,
Well, before we get too deep in this, I
Yeah.
want to just
Yeah,
get
sure.
an overview. Joe, can you tell us about the lawsuit that challenged Musk's pay package? Who filed it? What did it allege? What did the defendants assert in response, without getting into the substance of the decision yet?
I'm going to try to make something very, very complicated, very simple. The plaintiff in this case is a guy by the name of Richard Tornetta. You know how many shares of stock in Tesla Tornetta held that he undid this 56 or $2.6 billion package? 9.
Okay.
9. Okay. So compared to Musk's holding, nothing. But this is one of the interesting and fascinating things about Delaware law and corporate law in general. The smallest of shareholders, through the leverage of the legal process, can have the largest of consequences. Another way to look at this is the real plaintiff here was the plaintiff's law firm that actually argued this case and drove to this remarkable result, the Bernstein-Litowitz firm, Greg Varallo. So when you say, who's the plaintiff here? It's an interesting question. The formal name on the complaint is Tornetta, 9 shares. The real, the real force behind this, if you just want to look at the intellectual force, has got to be the Bernstein-Litowitz firm. Now, what's the allegation? The allegation is basically that the compensation was set to a conflicted process. And because it was conflicted and the conflict wasn't appropriately cleansed, instead of applying the usual business judgment rule that gives the board tremendous discretion in terms of where it sets the compensation, the board bears the burden of demonstrating something called entire fairness. And that is the strictest standard that applies under corporate law. And it's very hard for boards to satisfy entire fairness. It's been done, but it's the highest bar to sail over. What do you need to do in order to establish entire fairness? You need to establish that the procedure was procedurally fair, and you also need to establish that the result was substantively fair. So if you fail either on procedural fairness or substantive fairness, you lose. You have to win on both. And very importantly, the burden is on the defendant. So the defendant has to demonstrate, and the plaintiff doesn't have to establish, procedural fairness and substantive fairness. Well, what were the problems here with procedural fairness? First, the court for the first time ruled that Musk is a controlled person of Tesla. Control. If you've got 50% or more of the vote, the courts will assume that you've got control. If you've got a stock position that's significant but less than 50%, the court looks at a melange of facts and circumstances. Here, the court looked at the relationship between Musk and Tesla, and it said, even though your position is 21.9%, which technically is not a majority position, so you can't dictate every result, we look at all of the other factors, all right, and we conclude you're a control person. In addition, the compensation committee was found to have been conflicted because of the thickness and the financial and social relationships, and the court didn't get into this, but Dave points out the Wall Street Journal the other day ran an article about members of the board doing drugs with Musk and all sorts of other relationships, which is additional stuff that is not in the opinion, but clearly is going to be in the public.
But a lot of social and investment relationships with, I mean, Delaware has been, let's say, moving in that direction for quite some time when evaluating independence of the board members.
Exactly. And then there was an effort to cleanse these situations by having a stockholder vote. A significant majority of the stockholders approved it, but the court found that the proxy statement was sufficiently inaccurate that you didn't really have the full cleansing effect of the stockholder vote. So, so for example, it didn't accurately describe the relationship between the directors and Musk, and the directors were not actually independent as the proxy statement claimed. And that's one of the several reasons why you didn't have a conflicted transaction. So at the end of the day, what do you have? The worst possible standard applied, not worst, the strictest standard applied by the court to the board's behavior. Why? Because of the conflicts, lack of independence, lack of cleansing effect. Combine all of those factors, the board has to establish procedural fairness. That's a total fail. And then it has to establish substantive fairness. That's where the court comes in and second guesses, as a practical matter, the board, and in effect says, this is too much. This is an outrageous amount of compensation. You could have gotten him at a lower price, which I think in many ways is the intellectually far more challenging aspect of this opinion.
Well, let me ask you, Joe, do you think Chancellor McCormick was correct to apply the entire fairness standard?
Yes. I mean, given Delaware law, if her findings are correct, you have to apply entire fairness. To me, the really intellectually interesting question is when she gets to the challenge of, gee, you could have done a better deal in terms of negotiating compensation with Musk.
Well, so that's the next question. Do you think she was correct in finding that the package was unfair, both in terms of process and price? And do you think this approach to compensation creates the right incentives for executives?
Dave is one of the world's leading experts on executive compensation, so I'm going to let Dave embarrass himself first, and then I'll embarrass myself.
Okay. Yeah, I mean, it's let's not kid ourselves. Executive compensation, there's an economic and accounting aspect to it, but there's a lot of art form as well. I mean, it's not like there's scientific principles where it's like, here's the exact number. I mean, when I looked at that contract back in 17, 18, I mean, I kind of looked at it and said, this is a big number. It could pay out in a big number, but it only pays out if there's a lot of value created. And, I'll do the Grundfest thing here a little bit. Let me simplify it to the grisly terms. If someone came up to you and said, if you give me 12 cents, that is the 12% of the company, and I'll give you $1 back, would you take that deal? And, I think you take it most of the time. I mean, the court decision kind of went on and on about, well, it's not kind of free for shareholders. And I really struggled with trying to understand, what she was saying in the opinion. It's a risky payout, but it's only going to pay out if giant value is created. And so I actually thought it was fine, particularly in an industry like this, where it's a little bit of a winner take all market setting, and somebody's going to win and kind of everybody else is going to lose. So you want tremendous incentives to be the winner in that sort of market. So yeah, I mean, I found it sort of odd. I mean, the other part of the opinion that I found odd, and Joe hit on this, is, well, you could have had a better deal. Well, the deal was he was paid only in this form. There's no salary, no nothing. And then she was saying, well, you own 21%. that ought to give you enough incentive. You don't need any more incentives. But if you take that to the logical conclusion, I mean, do shareholders want Musk to work for nothing? I mean, he's put in a lot of effort, a lot of time. I mean, it seems like he should share in that sort of compensation arrangement.
Now, Dave, Chancellor McCormick would jump on you with what you just said. She would say he's not working for nothing. A big part of Chancellor McCormick's logic was she observed that, wait a minute, Musk has 21.9% of the company. So for every dollar he's able to increase the value of the company, he gets 21.9 cents already. And what she's basically talking about is, what's the marginal incentive effect of this additional compensation? If we want to talk what she's put in legalese in her opinion and translate that into modern microeconomics, she's making the observation, she's making the claim that given his equity position in the company,
It's already enough. Yeah.
You don't need to give him more. He has enough. And in support of her position, she points to Zuckerberg, Bezos, and Gates, all of whom were in the equivalent areas of multi-billionaires with 20 plus, percentages, and who agreed to work for $1 a year because they said, look, given my equity, I make the company. So those were her comparables. Now, that's cherry picking, because there are other boards where you've got executives who already have large positions who get additional equity and get additional comp. Interesting example, Larry Ellison, who used to be on the Tesla board, all right, and then dropped off the Tesla board, all right. He also has about a 25% position in Oracle, and he was also getting additional compensation. So while the chancellor is right to point to Zuckerberg, Bezos, and Gates, you could point to many other people who also have significant positions, are billionaires, but are getting more. Right? So that's one other approach. And look, what I will predict is that plaintiffs' lawyers are going to look at the logic, and they're going to press the logic of this opinion. And part of the logic of this opinion is that at some point your equity position is large enough that an effective board won't give you any more equity. So you will now have litigation, my prediction, no predictions whether wins or loses, against Oracle, where they're going to quote from this opinion and they're going to say, even though the business judgment rule applies, let's assume, this is some form of corporate waste, breach of fiduciary duty, um, to give Ellison more equity when he already has 25% of the company. And they're simply going to quote this opinion and say, well, you can't give Ellison any more. And they're going to be going down the list of every CEO that has, I'm just going to make up a number, 15% or more of the company.
Hmm.
They're going to argue that that's enough. All right. So there's sort of like, you get two helpings at the all you can eat salad bar, and then they cut you off. Dave, what do you think?
No, I mean, I I want the compensation to be set in a market setting. Except in egregious cases where there's fraud or really bad behavior. I don't want the courts to, put a top on this thing. I don't want the government, to put a top on it. If you go back to the Sarbanes-Oxley and kinds of things. I mean, in the original reports, they were saying, well, we're going to cap pay at some multiple of, average worker or whatever. I don't think that these are simplistic solutions to really complicated problems. You're messing around with the incentives of people that can create a lot of value if they're focused in the right way. And the way the system's set up, and I agree with it, is if you have equity position in this, it's going to give you tremendous incentives, and you ought to be paid accordingly for creating a lot of value. And again, it's not like you're getting cash salary. I mean, these are risky sorts of equity arrangements, and it's the pat solution of a complicated problem is typically not one simple recommendation. It's way more complicated than that. And I think I worry about who's pushing this. And I like the idea of having disinterested independent board members that are smart debating this and setting compensation. But obviously the opinion went a different way in this specific case. But I think Joe's point about all of a sudden, here's other people that have a big position, they're still getting equity grants or being paid compensation. Are they going to get sued based on this kind of opinion? I mean, I'm not a lawyer and it's a legal sort of issue, but that's a frightening sort of thought that would come to that.
Dave, my bet is they will get sued. The more interesting question is, on what set of facts might they win? The other observation that I would share is Kristen correctly pointed out that the court described the compensation here as an unfathomable sum. But I would amend that with Dave's observation that the deal was, if you achieve an unfathomable and unprecedented result, we will pay you an unfathomable sum. So if you reframe the compensation that way, it's a totally different perspective. Also, you get a totally different perspective if you say, wait a minute, what's the relevant number? Is it the 58 billion or is it the 2.8?
Yeah. Yeah, she had a lot of discussion in there about, and maybe we're going down a path outside of the what Kristen wants us to do. So rein us back in, Kristen. But the lack of benchmarking, and these kind of things, and you kind of go, yeah, in a normal setting, sure, you're going to do a benchmark, you're going to have here's a set of 25 competitors. I mean, I think that one of the experts said, we didn't do this because there was nothing to learn. And, she found that really objectionable. And I found it to be a very kind of small point, but, it was kind of something that was talked about a lot in the opinion that here's an example where the process is not right.
So Dave, you're exactly right to focus on that. Because the usual operation is a board will reach a decision, they'll have an outside consultant.
Right.
They look to the outside consultant as a blessing. Well, here, any rational outside consultant would run screaming from the room because you'd say, gee, how do we work? Well, we work on the basis of comparables. Is there any comparable to this situation? Hell no. All right. Well, how am I then, as an expert, going to bless a situation where when I run it through my data bank, there's nothing comparable? I got
That's
nothing
right.
to say.
But I mean, you're an advisor to the comp committee. The comp committee makes a decision, right?
Right. And
Yeah,
if I'm the advisor, I say, look, there is no comparable. You already know that. It's
yeah.
33x the last deal. It's 250x of the multiple. All right, it's up to you.
But let me
I can't bless this with my holy water
Yeah.
because I don't have holy water for something like that.
jump in here. We touched on this a little at the beginning, but I'm curious, Dave, what happens now to the 2018 pay package? Is it just thrown out and the board starts all over and comes up with a new proposal?
Well, I mean, I think we're in kind of uncharted territory here. I mean, I'm sure this pay packages have been rescinded like this in the past, but not of this order of magnitude. And so I really, it's really a legal question, but yeah, I mean, I think you have, I don't know the legal thing. You have like 30 days to appeal, and legal experts have weighed in on whether an appeal would be, you know, successful or things like that. But I think it's really a legal issue as to what happens. I don't know, Joe, this is more your thing, right?
My bet is it gets appealed. Uh, what I would also advise is that they look at a pragmatic fix. In other words, we gotta pay Musk. You want to keep Musk, all right? And then the question is, how do you go about doing it in a way that's compatible with the laws? The law exists. So here's what I would do. I would advise the board of Tesla, guys. First, name 3 special purpose directors. Find 3 people, clearly competent, clearly independent. They come onto the board, all right, you nominate them to the board. They work for a fixed fee. Their resignations are already signed, and it basically says, once we're done with our job of setting the compensation, we resign from the board. Okay? You can have, if you want to keep them away from other decisions, there are ways to design special committees and the like. So these people come on the board, and pragmatically, you can say you got one job: negotiate a comp deal with Musk. All right. This new committee of independent directors, you can't charge them with social thickness or any of this other stuff. They're very good about the process. They pay attention. They do all of the stuff. They hire the consultants. The consultants say, we got nothing to do to help you. All right, here are the prior limits. They do a proxy statement that is entirely transparent. They over disclose. But when it comes to the substance of the actual comp package, it is now, I think, easy to do the give and the get, where the court, where Chancellor McCormick said, gee, for the amount you gave, you didn't get enough. And Dave and I can argue with each other and with the court about whether that's right. But now we've got an interesting situation. Musk has said he's not sure he wants to develop all of the AI within Tesla. Aha, there is the give. Renegotiate the package and basically say, Elon, we're going to give you a rich package, and maybe a piece of it is designed to make up for what you lost in the last package. And we can do that because we are a new committee, an independent committee. All right. And we're going to get deference that the court otherwise didn't give. Plus, you throw in all of the AI stuff, and we wind up giving you another bazillion dollars. That is a different path to resolving the challenge. And it's different from assuming you appeal up and you wind up winning on appeal and vacating all of the decision below.
Joe, sorry, could a special committee of independent directors come on and approve the exact same pay package that was just rescinded? If the process is fair, they're deemed independent, there's negotiation.
I would prefer, let's put it to you this way. That raises the question that the court would then have to say that Chancellor McCormick was entirely incorrect with regard to her view as to substantive fairness. I don't think that that is likely to happen. For that reason, I think it would be better to modify the give-get and throw the AI development into the soup. You throw the AI commitments in there, and then it's a totally different case.
Yeah,
In the wake,
the
oh, go
complicated
ahead,
feature,
Dave.
I'm sorry, the complicated feature is right before the opinion, Musk was quoted as saying, I got to have at least, I forget what it was, 20% of the vote or something, or it's just not worth my time and effort. I mean, there was a lot of other things floating around. And you would think a special committee like this, it, it's an interesting question. It's unlikely they would approve that package, but there would be, I'd say, more discussion, more justification, more entertaining things. Now it's a negotiation. How that would play out, who knows, right?
Yeah, and the other thing is, it's like a negotiation in a bilateral monopoly monopsony situation. Each party, in a real sense, needs the other.
Yeah.
There really is no other good substitute, and none of the economic theory in the world will give you the solution to the monopoly monopsony negotiation. It's an arm wrestle. Dave?
Yeah, no, it always is in compensation. It's the one thing you do on a board that directly affects the pocketbook or wallet or whatever of the executive. It's always a justification, or there's a justification for this type of thing. It's just that this package is so unusual and so big that there's just not much to follow on. Joe laid it out, saying, the typical comp package, they could be big, I don't know, 20 million, 25 million, whatever, but some justification, here's the targets that were set, here's some benchmarking, that type of thing. This is just very, very unusual.
Right. And the other point about the unusualness of this is, if you go back to the comps that Chancellor McCormick looked at, in particular, Bezos works for $1. Zuckerberg works for $1. All right. Gates works for $1. The mentality in making those decisions might have been, gee, I get a regular CEO package, which is worth maybe 100 million, 200 million, 300 million. Well, I'll give that up and I'll do it for $1 because, 100 million doesn't mean anything to me. But if you'd go to Gates and you'd say, Bill, we're not talking about 100 million, we're talking about 56 billion. He goes, aha, I won't give that up. So when Gates made that decision, and Zuckerberg and Bezos, their comp may have been the usual package that a consultant might have come up with, and they weren't thinking to the moon, all right, like Musk was thinking. They weren't even conceptualizing the possibility that they could get $56 billion. So it may well be that these dollar-a-year comparables aren't really as comparable as Chancery suggested.
Let me switch topics slightly. In the wake of Chancellor McCormick's decision, Musk has very publicly threatened to reincorporate Tesla in Texas. This comes as Texas is setting up its own business court network, which could challenge Delaware's preeminence. What do you see, Joe, as the legal repercussions if Musk tries to follow through with this threat?
Well, this is a new form of immigration into Texas. All right, I think he's seeking some asylum from what he views as persecution in Delaware. What's interesting is this question of reincorporating out of Delaware is live. TripAdvisor is currently pending in Chancery. The issue there is very similar in the sense of Delaware courts apply the entire fairness standard or the business judgment rule. If it's entire fairness, it becomes harder to leave Delaware and reincorporate in states like Nevada and Texas. If it's business judgment rule, then it will likely be relatively easy to do. And much of the analysis will be the same. Is this a conflicted transaction in the sense that there's a benefit that inures uniquely to the board and to the CEO by shifting the state of incorporation from Delaware to Texas? And this is legally, economically, and politically a fraught question. Because if Delaware's analysis is, in a sense, too strict and says, here are the barriers you have to go over, people will then start calling Delaware a roach motel that you can incorporate into Delaware, but you can never leave. And that's not necessarily a good look for any state.
All right, last question for both of you. What lessons does this decision offer to boards of directors at other public companies? And as part of your answer, can you note any key steps that boards should be taking now in light of the decision? And let me start with you, Dave.
Yeah, thanks. So I think, Tesla clearly is an unusual board. And, you have a high profile CEO, very smart, made lots of fantastic advances and created a lot of value. I think that when you look at the board, I think there are a variety of these social or business connections. I think a rational person would look at that and say, how independent is that board? I think the court decision, I think, correctly said, let's take a closer look at this. And the opinion went through, each person and things like that. And I think the learning of that is you want to probably do the reality check on how independent are these people, and look at these social and business contacts. And I think that's part of it. But the other part is, are they independent minded? Are they doing something that's arm's length, that seems sensible, things like that. So I think, this is not, that insightful, but I think boards are, probably are going to take a closer look at, if we got sued over this kind of thing, and, how independent is this compensation committee? And so but I mean, this is just a matter of degree. It's just gigantic. But, even, lots of companies are still paying their executives, tremendous sums of money. And I think it's worth looking at that. Just how independent are these people? Should there be some rejiggering of the comp committee, things like that. But the other thing I'll just sort of say is, this is sort of a kind of a little bit of an accountant's view. There was some discussion about what was disclosed in the proxy statement. Was it sufficient for, shareholders to vote on it? The say on pay vote was a vast majority said okay, even though the proxy advisors, I think, both recommended against this. But I think some of the things that she brought up were, well, what's the probability that you're going to hit these targets? And her view is they were the first 3 years or first 3 tranches were gimmies. I'm not sure, those are out of corporate strategy. That's proprietary information. It doesn't seem to be appropriate disclosure. And she seemed to object to that there wasn't enough, background. So I guess the punchline is, review, this is an every year kind of thing, but really reviewing what the disclosure about comp plans, if they're unusual, is probably something that you need to think more about at the board level.
I'm going to wind up violently agreeing with Dave. The first thing that's most important for the vast majority of publicly traded corporations is just avoid full entire fairness review. How do you do that? Well, we have sufficiently independent directors, all right? They hire the consultants, they pay attention to the consultants. You don't have the kind of communications that suggest that the comp committee is under the thumb of the CEO. And then when you come forward, you make sure that you do all of the appropriate disclosures if you need a shareholder vote in order to cleanse, and then you're going to likely be okay. Let me expand on Dave's view that I also find it quizzical in a certain sense that the court said, gee, maybe you should have disclosed the 70% targets. I haven't done a full study, but I have no present recollection of ever seeing any publicly traded company say, here are our targets, and we think that there's a 70% chance, or an 80% chance, or a 23.69872% chance of these targets actually being met. All right, I'm not saying it hasn't ever happened. I just have no present recollection of that in this context.
Great.
So
Any other
stay tuned,
points?
huh?
Yeah,
Any other? Go ahead, Joe.
No, that's a knowable question, Dave.
Yeah.
We can throw a couple of research assistants at that and have an answer by tomorrow.
There you go. There you go.
Any other steps that boards should be taking now, Joe, that you wanted to highlight?
No, I think, you know, the key point for the vast majority of publicly traded corporations, and for the vast majority of them, it'll be relatively easy, is simply avoid entire fairness review. Independent committee, good processes, you're going to be fine.
Great. Well, Dave, Joe, thank you so much
Yeah.
for joining me today.
Thank you. Yeah.
Thanks.
See ya.
Thanks to everyone in the audience for tuning in. See you next time.